All right, let's dive right into this explainer with a high-stakes scenario. Imagine you're representing a company, and a rogue employee or a corporate pirate has just stolen highly confidential trade secrets. You know exactly where the evidence is, but you also know that the moment you serve them with a standard lawsuit, they are going to hit delete or throw those crucial documents straight into the shredder. So how do you stop them? How do you freeze the scene before the evidence vanishes into thin air? Well, to save that evidence, the law gives us what is essentially the ultimate legal weapon, the Anton Pillar Order. Named after a famous 1976 English case, this is a highly specialized mandatory injunction. It's granted ex parte, meaning you go to the judge entirely in secret without tipping off the defendant at all. If the judge agrees with you, you get the extraordinary power to show up unannounced at the defendant's premises to search, seize, and preserve that vital evidence for trial. It's basically a legal shock and awe tactic. Welcome to this explainer on drafting an Anton Pillar Order A to Z. We're going to take a complete chronological journey, a legal search and rescue mission, if you will, from drafting this draconian order all the way to actually executing it on the ground. Here is our roadmap for this explainer. We've got 6 distinct sections to get through: the ultimate legal weapon, the 3 golden rules, drafting the affidavit, crucial legal safeguards, executing the order, and finally, the defendant's rights. Moving right along to Section 1, the ultimate legal weapon, and crucially, why it is not a search warrant. You know, it's incredibly common to confuse an Anton Pillar Order with a standard police search warrant, but they are vastly different animals. A police warrant, that's a criminal tool. It lets officers literally break down a door if they need to. But an Anton Pillar Order is civil. It operates in personam, meaning it's directed at the person themselves. You absolutely cannot break down a door, sneak in through a back window, or use force. Instead, it uses immense legal pressure to force the defendant to let you in. If they say no, they face contempt of court. It's really a game of legal leverage, not physical force. Section 2, the 3 golden rules, also known as the Anton Pillar KG requirements. Because this tool is so invasive, you're literally letting private citizens search someone else's property. You can't just ask for this on a hunch. You have to meticulously prove 3 things before a judge will even look at your application. First, an extremely strong prima facie case. No guessing allowed. You need to show a highly probable chance of winning at trial. Second, the potential damage to your client has to be very serious. Think total business collapse. And third, you need clear evidence that the defendant actually possesses these documents right now, and there is a very real possibility they'll destroy them the second they find out they're being sued. Section 3, drafting the affidavit. This requires strict compliance with Order 29, Rule 12A. This ex parte affidavit is your recipe, and it's where cases are won or lost in secret. You've got to include the facts of the claim, why you need the injunction, and exactly why you couldn't give notice. But look at those middle bullet points. Because the defendant isn't in the courtroom to defend themselves, the law actually forces you, the drafting solicitor, to play devil's advocate. You literally have to outline the likely answers or defenses the other side would use, and state any facts that might make the court say no to your order. If you leave out a single ingredient or try to hide a weakness in your case, boom, your application gets thrown out for suppressing material facts. To give you an idea of what this looks like in practice, here's a snippet from an actual Malaya affidavit invoking the court's inherent jurisdiction. Notice how formal and structured it is. The deponent is swearing under oath, often backing it up with expert tech reports to convince the judge that if regular notice is given, all that digital evidence will be wiped out in seconds. All right, Section 4, crucial legal safeguards and the duty of the solicitor. Because the court is handing you so much power, they demand immense responsibility in return. As the landmark Malaysian case of Maka Angka Electronic makes crystal clear, the drafting solicitor carries a really heavy burden. You are an officer of the court first. That means full and frank disclosure is non-negotiable. You have to draft the order to be minimally invasive. No fishing expeditions allowed. Plus, you have to make sure an independent supervising solicitor is there during the execution just to keep everyone honest. Another mandatory safeguard you have to draft is the undertaking as to damages, or the aku janji ganti rugi. Since this order happens entirely in secret, there's always a risk the court got it wrong. If you raid a business, shut down their operations, and it later turns out your case was completely baseless, their business could be ruined. So this undertaking is a legally binding promise from the plaintiff to pay damages for any unjustified harm caused by the order. Section 5, executing the order.
knocking on the defendant's door. This is where theory meets reality. Execution is a highly choreographed sequence. You can't just show up at 3 a.m. You have to arrive at a reasonable hour, and you bring that neutral supervising solicitor we just talked about. You serve the order, explain it in plain language, and ask for permission to enter. And this is key. Based on the Bimji and Chetwani case, this isn't an ambush. You must give the defendant a reasonable amount of time, usually up to 2 hours, to call their lawyer and get advice before you step foot inside. Only then do you execute the search peacefully. And finally, Section 6, the defendant's rights, covering refusals and contempt. Even with a flawless order, human nature takes over. If a defendant panics and unreasonably denies entry, remember the golden rule: no violence. You cannot shoulder down the door, you just document the refusal and leave. But the consequences for the defendant are absolutely severe. By defying the judge's order, they could be held in contempt of court. We're talking actual jail time or massive fines here. Plus, at the eventual trial, the judge is legally allowed to draw an adverse inference. Basically, the judge assumes whatever they were hiding must have been terribly damaging to their case. To wrap up this explainer, let's look at a really provocative question about the friction between civil search orders and fundamental rights. If the documents you're seizing prove the defendant committed a crime, like theft or criminal copyright infringement, does forcing them to hand over those files violate their basic right against self-incrimination? Surprisingly, according to the PMK Raja case in Malaysia, yes, the privilege against self-incrimination actually survives this process. The reasoning here is fascinating. An Anton application is just an interlocutory pretrial proceeding, so the defendant hasn't officially been sworn in as a witness under the Evidence Act yet. Because of that, they retain the right to refuse to hand over specific documents if it would expose them to criminal charges. It really makes you wonder, right? How well does this ultimate weapon balance the ruthless pursuit of civil justice with protecting fundamental human rights? It is a serious legal tightrope walk and a brilliant reminder of just how complex the law can be.